Good morning and welcome to Coffee Talk, our health seminar series. My name is Kathryn Frelick and with me is Parrish, and we are delighted to be speaking to you today about how to proactively manage and effectively respond to civil litigation risk. The presentation, we're trying a new format today. We're very excited about it. We will you'll have the opportunity throughout the presentation to ask any questions through our chat box. We will try to address your questions either during the course of the presentation or at the end in a Q&A period. So please bring your questions. We may not be able to respond to all of them, but if not, you're encouraged to reach out to either one of us at the information on our slide. So without further ado, today we're going to address three areas. One, strategies for avoiding a lawsuit. Secondly, how to identify a potential lawsuit. And third, we'll talk about the claim process a little bit and how to manage civil claims. Well, where do lawsuits come from? They come from any number of places, actions or events that are unanticipated or unexpected. If there's a poor outcome, where there's been a critical incident or an adverse event. It can also be failure to comply with legislation. For example, failing to comply with privacy obligations through unauthorized snooping of records of health information. Or in most cases, and this is sort of a general basket, which we see in almost every type of litigation that we're involved in, as a result of poor communication or the failure to communicate effectively to patients, clients, employees, or to others. Many times it's the managing expectations or there is some communication breakdown or failure in the process. Sometimes it can be bad luck, and bad things happen sometimes. But with the strategies that we're setting out, hopefully it will place you in a defensible position. Some of the strategies for avoiding litigation we've set out here. It's important to ensure that you have up-to-date institutional knowledge of legislative requirements and standard of care. It's the obligation of the board of directors of the corporation to ensure there are effective systems in place. And that includes ensuring that there's compliance with legislation. Boards are required to sign off on an attestation once a year as part of their funding agreement, attesting to compliance with laws. And so in order to comply, they need to know what those regulations are, whether they are broader public sector accountability requirements, ECFA, privacy, or professional standards and industry standards that evolve over time. Up-to-date policies goes without saying to support compliance with legislation and standard of care. And in order for policies to be effective, you really should be looking at them as risk documents and either being in place to support clinical decision-making in the case of clinical policies, to enable the organization to establish that it's balanced the right risk considerations. If it's a least restraint policy, that you have used those measures after, as a last resort, have looked at all of the alternative measures before restricting someone's liberty in that way. Or to ensure compliance. And medical assistance in dying is a good example. It's a very legislative process in terms of the criminal code requirements, and having effective policies are really crucial to ensure that you're actually following the law. Effective employee training to ensure compliance with policies is important in order to comply. Again, employees need to be aware of the policies. They need to know where to find them, and they need to have somewhere to ask questions. One of the key areas of risk is the responsibility to ensure compliance with policies and procedures. So it's not enough to have them in place. You need to ensure that they're being audited, that your personnel are following those policies, and that you have review measures in place. Comprehensive review of employee qualifications and physician credentialing. It still is remarkable at times when we discover a person in a health professional position who doesn't have the proper qualifications or isn't licensed. It does happen from time to time. Making sure you have diligent processes in place to check credentials, references, reference checks, all very important. And finally, having a fulsome dispute resolution and patient relations process in place can be key to managing issues in an early stage, as early as possible, when there are concerns or complaints. Or in the case of dispute resolution, there are many forms of alternate dispute resolution that go on a day-to-day basis, whether it's negotiating end-of-life disputes, mediating with family members and substitute decision makers, and negotiating to come up with a plan of care that will that can go forward and allow you to provide the care you need to provide. So effective communication to reduce risk is especially important in this day and age where we have a number of quality of care and patient safety obligations in conjunction with the issues relating to risk that you are managing internally. And again, you can look at these processes as opportunities to communicate and to manage and reduce the risk to the organization. And part of that is through having patient safety reporting obligations so that staff are reporting those issues as they come up, having a critical incident reporting process so that you can manage incidents where the results are not as anticipated. The whole disclosure of harm process really relates to informed consent and the right of the individual not only to know about their care and treatment, but also any harm that's resulted as a result of that care and treatment. And finally, again, I've mentioned those patient complaints and patient relations processes. Just pause a bit to talk about apologies. And we do have legislation in this province and in a number of other provinces that recognize that an apology made by a person in connection with a matter is not an acknowledgement of fault or liability and can't be used against an organization or an individual in connection with that matter as a admission of fault or liability. It also prevents the voidance of insurance or indemnity coverage for persons. So in the old days, there was a concern that if you apologize, then the insurance company would not support you and defend you in relation to a matter. But what is an effective apology? And there's a real art form to making an effective apology. Of course, it includes a sincere expression of regret, but what we've learned is that individuals want more than just to hear those words of regret. They want to know that their issues have been heard, that the organization has considered those issues, and they also want to know that what steps you've taken to try to address those issues. So when I'm talking about an apology, I like to look at it in a broader, more holistic sense in terms of what is really going to reassure the person that you've really heard and addressed their concerns. There can be many other processes that are going on in conjunction to the risk of litigation. If there's a death involved, there could be a coroner's investigation or potentially an inquest. There are often health professional complaints that are made when a family member or a patient is concerned about the care that they've received. There can be a number of different investigations by the Ministry of Labor, the Ministry of Health and Long-Term Care, particularly in the long-term care environment where you have critical incident reporting, patient ombudsman complaints, privacy complaints, and then, of course, issues relating to your human resource and professional staff processes. One note on privacy and freedom of information requests. One trend that we have seen is not only are individuals seeking information through the litigation process, and in the past, that's been one of the only places where they could sometimes get that information. Individuals are now seeking that information through other processes, whether it's the complaints process or through freedom of information requests. And we have seen from some of the recent FIPA decisions, and in particular FIPA decision number 17, that if the individual patient is identified in any manner, then those records may be subject to a PHIPA request, regardless. They may not be something that's producible, but they may be subject to a request for information. Some other strategies that I wanted to touch on are contractual protections. And again, it's important to look at your contracts as risk management documents. They can either put you in a place where you can defend an organization, you can address issues around allocation of risk, indemnity, and insurance. Contracts will set out the roles and responsibilities of the parties, and will also allow you to enforce your rights in situations where your contractual rights are being infringed. For example, one of the areas that we of a lot of concern are those involving information technology. What do you do if the multi-million-dollar information technology isn't working the way it ought to and is potentially impacting on patient care? Without having contractual protections built into that contract, your remedies may be quite limited. So ensuring that you have a fulsome contract review process and that you have those protections built in is a key risk management strategy. Conversely, in this day and age, where we have many different collaborative care models, having an agreement that sets out what the roles and responsibilities of the parties are, how you're going to interact, what you're going to do if there are issues or complaints, and dealing with risk allocation. In this day and age, we like to talk about memorandum of understanding that are between different partners. I just make a note that if it's intended to be a binding on the parties, it's probably an agreement. If it's not, it could be a memorandum of understanding, or it could just be a policy. So look at the intention of the parties and what you want to achieve, and then look at putting in place the right documentation to protect you from risk. It goes without saying that comprehensive record keeping is key, including having information management processes in place. One of the doctrines that we see in litigation is a doctrine called spoliation of evidence, which can be brought if documents have been destroyed by a party, and where a negative inference can be drawn against that party. As long as your documents are being managed in accordance with your document management processes, that you have retention periods, documents are being destroyed in compliance with that process. Or if you have a records hold, if you're aware of litigation, that you're preserving those records so that they aren't destroyed, then that's a very good defense against claims of spoliation. And I can tell you, it can be very difficult to defend a claim when there are no records that exist. It can be hard to prove it, but it can also be hard to defend. Other strategies: having a comprehensive incident management process, and that's dealing with safety, patient safety incidents, as well as employee incidents, slips and falls, anything that might create risk for the organization. And then finally, having appropriate investigation and follow-up for dealing with patient complaints, adverse events, and critical incidents. One of the key bits of advice that we provide is to make sure that you engage legal counsel early in the process. And that doesn't mean that legal counsel is going to be fully involved while you're doing that initial investigation, but it does allow you to establish solicitor and client privilege, where the communications are taking place for the purposes of obtaining legal advice. And it also, we've been through this many times, and we can often provide advice and assistance, and perhaps help you with issues that you might not have thought of. In addition, having a risk management process in place to address key areas of risk, whether it's the preservation of evidence, if there's a coroner's case, ensuring that nothing is moved until there's approval from the coroner, making sure that you are securing the records, and not just the main health record, but any health information, digital imaging, diagnostic tests, records that might be kept in departments, so that you, Cardex, there are many types of records that are temporary in nature, but could be very useful to have, and from a defensive perspective, if you are proactive in preserving those documents. So how do you identify a lawsuit? Well, we want to make sure that our staff are anticipating potential lawsuits, whether it's through a complaint or a threat or a demand. If a threat or a demand is received, make sure that you identify and document the specifics in your risk management file. And I talk about a risk management file separate and apart from the clinical record. There may be certain statements, and if a patient is unhappy or their family members are unhappy, that could certainly be relevant to patient care and something that you document. But if there are issues and concerns about the processes or concerns that need to be escalated, making sure that you have a internal risk reporting process and documentation for the purposes of potential litigation or where there are risks that have been identified. Your internal risk reporting should have a triage and escalation process. So there's a screening that takes place. Certain types of risk or levels of risk can then be escalated if there are different processes for investigation and follow-up that need to be followed. There may be internal or external resources that you need to bring in depending on the issue. For internal issues, it could involve your risk, your senior leadership, HR, privacy, security, communications, IT, spiritual care, social work, depending on the type of issue and how you manage it. And then from an external perspective, legal counsel, there may be external consultants that you need to bring in to conduct a review, your insurer, or there could be crisis management and immediate crisis supports that you need to help manage the risk. Once a potential lawsuit is identified, make sure that you maintain detailed documentation, that you have the right people involved, that the right resources are triggered, and ensure that your investigation is protected if the intention is to protect it. So whether it's through QSIPA or through some type of legal privilege, if there are investigations being undertaken and there's a risk of liability, you want to make sure that you are establishing that privilege in a deliberate way and maintaining it throughout the process. And with that, I'll turn it over to Lauren.
Thanks, Kathryn. So moving on now to the claim itself, what are the best practices for managing the situation once you've been served with a statement of claim? There are a number of overarching principles to consider, and these should inform your management of the claim. And I'll go into them in more detail, but they're set out on the slide. And they include accountability to the patient and the public, understanding the litigation process, understanding the law, securing and protecting information, and supporting and preparing involved staff members. So the first principle is accountability to the patient and the public. At an institutional level, it's important to manage claims so as to ensure accountability to the patient, who at this point has become the plaintiff, as well as to ensure accountability to the public. Particularly where the claim arises from some sort of adverse incident, adverse event, it's important to investigate and respond appropriately to ensure quality of care and promote a culture of safety. This includes kind of isolating the incident, determining whether it is an isolated incident or part of a larger systemic issue. Throughout the process, the institution must ensure that patient information is being kept confidential and that proper authorization for release of information is received. Obviously, the disclosure obligations are triggered once there's active litigation. and certain disclosures can and must be made, but we always want to keep an eye to ensuring that information, and particularly personal health information, is being dealt with appropriately and in keeping with the legislation. In dealing with the patient and the public, it's important to avoid comments that impart fault on the part of the institution, on the part of staff, and alternatively, it's important to avoid comments that place blame on others. We find in our experience these types of comments may actually escalate the situation or complicate matters. Similarly, avoid making promises that are unrealistic. This can also escalate the situation and may even form part of the basis for the claim. It's important to ensure, and Kathryn touched on this, that the institution has a proper spokesperson, and this applies to various stages of the litigation. So on the front end, you want to ensure that an appropriate individual is tasked with coordinating and gathering information from the involved staff members. Later on down the line, it's even more important. It becomes a more formalized role, and you want to ensure you have an appropriate, informed corporate representative to be present for examinations for discovery, as well as an appropriate staff assisting in answering undertakings given at discovery. Second important overarching principle is to understand the process of litigation itself. And on the slide in front of you is set out the main steps in a civil claim. The first being the pleading stage. The pleadings refer to the statement of claim, the various statements of defense issued by the various named defendants. If we are representing a healthcare facility, the defense will be on behalf of the facility or the institution, as well as on behalf of any persons whom that facility is vicariously liable for, such as employees. Often this includes nurses, who are generally employees, and in that situation, a statement of defense would be on behalf of the institution as well as the nurses. Generally, but not always, physicians are independent contractors. As such, they'll generally have independent legal counsel provided to them, and they'll file their own separate statement of defense. And it's common for a hospital and a physician to issue cross claims as against each other. This is another type of pleading. And these are generally just for contribution and indemnity. So they're important. They preserve the right for a party to later seek contribution from a co-defendant for any amount that they might be ordered to pay to the plaintiff. So it really is a reservation of rights. In some cases, the plaintiff may have failed to name an important defendant in the statement of claim, and in this situations, we may issue a third-party claim in order to bring that party into the action so that all of the parties that might be culpable or might be involved are involved in that civil litigation. The second step in a civil claim is the documentary discovery phase. So once the pleading stage is completed and all of the defenses have been filed, the parties will exchange affidavits of documents. An affidavit of documents is a sworn document, and it includes an affirmation that every relevant document relevant to the matters at issue in the claim is included within that affidavit of documents. It's important to note here that it's a broad production obligation. The scope of documentary discovery, which is set out in the rules of civil procedure, states that any document relevant to any matter in issue in the action and in the possession, control, or power of a party must be disclosed. So because this production obligation is so broad, it's important, as Kathryn discussed earlier, that the institution has retained all of this relevant documentation at the first indication of a possible claim. And in this day and age, as we know, many things are electronic, and the scope of what we need and what needs to be disclosed is broadening, it seems, by the day. So your production obligation, it includes obvious things, hard copy documents, the patient record, but it goes beyond that. It can include witness statements, contemporaneous handwritten notes, beyond things such as reports on radiology imaging. It will include the raw imaging itself, and it can include all metadata. So it's really important to coordinate with your IT department early on to ensure that all of this information is retained and that it's kept secure, confidential, and available for disclosure. It's important because a negative inference can be drawn against a party if documentation or metadata or a record should be available and it's not. So as Kathryn touched on, it can be difficult to defend a matter when there's no documentation. It can be even more difficult to defend a matter when there should be and there isn't for some reason. That's certainly a challenge and something that we don't want to run into. Another important thing to note is that the production obligation is ongoing. So if documentation is discovered or new information is discovered 2, 3, 5 years into the lawsuit, the obligation is still to produce it at the time that it becomes in the institution's possession or control. Moving on from documentary discovery is the examinations for discovery. Every party who is named in an action must be produced at an examination for discovery. And this is why oftentimes you see in a defense specific employees, such as specific nurses, named individually, even though an institution is vicariously liable for them, whether or not they're named. Really, the strategic crux of that is that a plaintiff's counsel will likely want to be able to examine those specific nurses who were involved in the events at issue at an examination for discovery. The examination is conducted under oath. The questions are asked of the opposing party's lawyer, by the opposing party's lawyer, and the party being examined has their own legal counsel present who has prepared them in advance. And really the purpose of examination for discovery is true to its name. It's to discover anything that's unknown at that point about the events at issue in the claim. And the policy underlying that and the purpose is that we want our trials to be efficient. The adjudicators of those trials want to have all the facts. They want to be able to make informed decisions, and nobody wants to be surprised at trial. A transcript is made at discovery, and it can be used as evidence at trial. It can and is often used as well to coordinate with various experts to prepare expert reports, expert evidence that is used at the trial. After the completion of discoveries, there may be various pretrial motions or preliminary motions. Some of the common ones include motions seeking answers to undertakings. If a party doesn't have an answer at discovery, they can undertake to provide the information at a later time. And if they fail to do that, you can bring a motion to seek that information. There's a litany of pretrial motions that can be brought for various strategic reasons. Following motions, alternative dispute resolution may take place. In some jurisdictions like Toronto, it may be mandatory. Mediation is mandatory in Toronto. In most jurisdictions, it's not, but the parties may agree to mediation or arbitration of their own accord. The mediation is really a meeting facilitated by a mediator amongst the parties with a goal to encourage and foster settlement of the case. An arbitration is more quasi-judicial in nature. The parties make formal submissions before the arbitrator, who then makes a final and binding decision. If there's no success in mediation or arbitration, or those steps haven't taken place, the next step is a pretrial conference, which is mandatory. This occurs before a judge. It's not the same judge who conducts the trial, but really it's an opportunity for the parties to set out their evidence, set out their positions, and the judge can provide feedback on various strengths and weaknesses. Settlement is discussed if appropriate, and really it's a determination of whether the matter is ready to proceed to trial. And of course, the last step in a civil claim is the trial itself. Trials are not as common as they once were for a variety of reasons. There's a lot of time that goes into preparing for a trial. There's a lot of resources. But in some cases, it is the only way to resolve the dispute, and certainly there's many trials still happening. In a civil trial, an important thing to know is the standard of proof, and that's a balance of probabilities. So the plaintiff needs to prove, and the plaintiff has the burden of proving, that everything they've alleged in their claim is essentially more likely than not to have occurred. And of course, this is different from the criminal standard that many people are familiar with, which is beyond a reasonable doubt. And the last step really is settlement negotiations, and this can and should occur throughout the stage, throughout any stage of litigation as appropriate. It might be informal conversations amongst legal counsel, it might be a formal written offer to settle, but it's always something that one should have an eye to. And of course, if there is a settlement, an important part is securing a full and final release from the plaintiff that will protect you from any future claims relating to the same events that were at issue. A third important overarching principle is understanding the law itself at some general level. And the main claims that we see with respect to healthcare and the provision of healthcare are claims in negligence, claims in breach of contract, and claims with respect to privacy breaches. But even among these three, negligence claims are by far the most common healthcare-related civil claim. There are two main elements to a claim in negligence. Liability is the first step, and this asks the question of who is liable or who is responsible for an improper act or omission. The second is damages, which asks what harm, if any, did a plaintiff suffer as a result of this alleged improper act, and how can that be compensated and evaluated. With respect to liability, a plaintiff must establish four key things. They're listed on the slide above you. They need to establish that the defendant owed them a duty of care. They need to establish that the defendant breached a standard of care. They need to establish that they suffered a loss, an injury, or a harm. And they need to establish that the breach of the standard of care was the cause of that loss, injury, or harm. And that's an important point. So very briefly expanding on these, it's well established that healthcare providers owe a duty of care to their patients. So the first step of this is not often at issue. The standard of care it's a purely legal concept. It's determined by experts in the field based on a variety of factors, and it'll vary. It'll vary based on the healthcare provider and where they're located. So for example, an emergency department nurse practicing in a small rural hospital will not be held to the same standard of care as a nurse practicing in a major downtown core. And of course, a physician will not be held to the same standard of care as a nurse, and vice versa. So it's a moving and fact-specific legal concept that is determined on a case-by-case basis. With respect to harm, there must be some quantifiable harm to the patient. So a healthcare practitioner may fall below the standard of care in their treatment. For example, perhaps their charting is below what would be considered standard of care. But if that inadequacy or omission in the charting didn't result in any harm to the plaintiff, then that plaintiff won't be successful in their claim in negligence. And the last one that is really important is causation. And I touched on this, but there must be some nexus between the alleged negligent conduct and the harm. So to give an example, if a plaintiff, for example, alleged that there was harm to an infant because a nurse, let's say, failed to monitor fetal heart rate during labor, they would need to prove that it was that lack of monitoring that was the cause of the harm, and not say, for example, the fact that the infant was dropped after birth in the post-delivery kind of sphere of the care. So there has to be a nexus, and this is a really, really important part of the claim that a lot of time goes into evaluating. Who is liable is a question that comes up a lot. And often many parties may be liable for a harm that a plaintiff suffered. And with respect to a medical negligence claim, often both an institution and a healthcare provider are liable, and this is due to the concept of vicarious liability. So the Supreme Court of Canada has defined vicarious liability as occurring when the law holds one person responsible for another because of their relationship. It's not an independent tort, and by that we mean that there must be some independent liability on the part of a healthcare practitioner in order to hold an institution vicariously liable. This most commonly occurs in the employer-employee relationship, whereby an employer will be found to be vicariously liable for the conduct of their employees by virtue of the nature of the relationship. The tricky thing is, there's no universal test that determines who's an employee versus an independent contractor. This test is fact-specific. It's determined on a case-by-case basis. Generally speaking, nurses are employees of the institution, and generally speaking, a healthcare institution will be vicariously liable for their conduct. Generally speaking, physicians are independent contractors, and generally the institution will not be held liable for their conduct, but this can change. And it's also important to note that even where a physician is an independent contractor, the institution still has its own independent responsibility to ensure that that person is properly qualified, properly competent to provide the healthcare services that they are. So that's an independent institutional liability. And similarly, the institution has a responsibility to provide safe equipment and safe facilities. Liability and breach of privacy is an interesting and evolving area of the law. The short kind of answer to this is you can sue for breach of privacy. Sometimes a civil claim will include breach of privacy either in the context of negligence or as its own tort. And this is possible because in 2012, the Ontario Court of Appeal created a new tort, which they called intrusion upon seclusion. And this new tort is unique because a plaintiff does not need to establish that they suffered physical, financial, or other harm. The breach of privacy is in itself a harm suffered. And this tort has often been referred to as the snooping tort. It's a novel area of law in many ways, and it has been seen in the healthcare context where health institution employees have improperly accessed or snooped into medical records. And the question with vicarious liability is really, was that act of snooping sufficiently connected to the employee's assigned responsibilities such that the institution should be held vicariously liable for their conduct? And this question is unresolved. This law is unresolved in Ontario. There are a number of class action lawsuits currently before the courts relating to large-scale privacy breaches or snooping into medical records, but none of these cases have yet been heard on the merits. So it's really to be determined how the courts evaluate this. Going back to our overarching principles, another very important one that Kathryn did touch on is securing and protecting data. So different obligations exist with respect to disclosure of information versus reporting of an incident, for example, to an insurer or to a college. But institutions often have an obligation to obtain information. So an institution that fails to conduct a review can open itself up to criticism in a civil lawsuit. But it's important when doing that investigation and gathering that information to ensure that it's not being improperly disclosed, to ensure that confidentiality is being protected, particularly with respect to personal health information. As Kathryn touched on, if the goal is for information to be protected, the institution has to be very deliberate about the process. And it's a good idea to engage legal counsel early because there are different ways to safeguard information and there's different processes with respect to those various ways. So, for example, an internal audit or an internal review, that will likely be disclosable, but not always. However, information that's gathered for a quality review specifically will likely be protected under QCIPA. There's also, of course, legal privilege. Solicitor-client privilege can be engaged. There's also the concept of litigation privilege, which can be engaged if information is being gathered specifically with contemplation of or in response to being served with a civil claim. It's important to remember that privilege can be waived, so you want to be aware of these issues on an ongoing basis to protect those rights. And our last overarching principle is the concept of supporting and preparing staff. And this is an important principle. You want to identify and meet with staff members who are involved in the events giving rise to a claim as soon as possible. And this can often be facilitated with counsel in order to ensure solicitor-client privilege. Presenting the information giving rise to the claim is important, and we often ask as a best practice to seek witness statements from various involved parties before they've had a chance to review the medical record. And the purpose behind that is that we want to seek independent recollection or independent memory of events as close to the time that the events occurred as possible, because we know that memory is fluid, it can shift and over time. Identifying the facts that related to the events at issue is important to help address any systemic issues or failures on the part of the institution. And the goal here is, of course, to manage institutional risk and to avoid a similar sequence of events in the future. So identifying what other supports an employee may need is important also from an internal risk management perspective. So it might be things such as mentoring to improve practice. It might be independent consultation with legal counsel to discuss any questions they may have. Sometimes this is really helpful to kind of ease the tension or stress that comes when an employee has been named in a lawsuit, which is, of course, inherently stressful situation. So it's important to support staff through the process in order to manage risk in the future, but as well, given that it is a stressful situation. So just a review of our risk management strategies. I'll turn it over to Kathryn to wrap it up.
Thank you. And effective use of your tools and the risk management strategies can be key to avoiding and managing risk, ensuring that you know the law as it changes and evolves, as well as professional standards as they change and evolve, and entrench that in your policies to assist with decision-making, to enable compliance, and to allow the organization to be in a defensible position in the event that there is a claim. So by this, I mean being strategic and deliberate in the drafting of your policies when you're working in key risk areas where you know that there's going to be a challenge. Often we are able to avoid the challenge by having those policies that we can rely upon, and knowing that there really isn't a basis to challenge them, or if there is, we're in a position to be able to address that. With employee training, there's so much information that is out there, making sure that they're getting the right information, that they know where to find the right information, and where they have questions, having processes in place to escalate those questions and to ensure that there are individuals within the organization who can address the larger corporate issues. One of the things that we are certainly seeing in this day and age is the use of social media and court of public opinion. There's a real reputational risk for organizations when there has been an event or a critical incident or disputes relating to alternative care, ALC and alternate levels of care. When we're dealing with scarce resources, when we're dealing with hallway patients, et cetera. So looking at all of these risks, not only from a risk management perspective, but an enterprise risk management holistic view to ensure that you are pulling together the different silos and areas within the organization, whether it's privacy, quality, HR, patient relations, and in some organizations, a single individual may have, wear a number of hats and have those roles. But it's not adequate anymore to address issues in silos because you'll likely miss the bigger picture if you're not looking at these risk issues holistically. So we hope that the presentation has been helpful. If you have any questions, please submit them now or feel free to reach out to Lauren and I. We don't have any questions so far. So while I'm doing our wrap up, if there are additional questions, please feel free. We appreciate you attending our session. Our next Coffee Talk presentation will be on Ontario's new Construction Act, what you need to know, and that will be on May the 16th. Please also feel free to take a few minutes to complete our survey and to provide your feedback, including feedback on our new format. We hope you enjoyed it. As there are no questions at this time, we're going to sign off. So thank you very much, and have a good day.